my name's Clive Rich. I'm the founder and CEO of LawBite. So my background is as a barrister. I've been a lawyer for well over 30 years. I started my career working for big media tech companies, Warner, Bertelsmann, Sony. I ran legal and business affairs divisions for them, and then I graduated to running profit centres. I ran digital businesses for both Bertelsmann and Sony, and then came up with the idea for LawBite. And LawBite is dedicated to democratising the law for SMEs. So I'm here to talk to you today about disputes. What do you do if you find yourself in the unfortunate position of having to manage a dispute as an SME? So there are three potential routes you can go down if you want to go down the court system. The first is the small claims track, which normally caters for claims of up to £10,000. So that's a relatively quick and inexpensive procedure. For claims between £10,000 and £25,000, there's something called the fast track procedure, which is a bit more expensive and complicated than the small claims track, but still not too bad. And then for more complicated claims than £25,000 worth of claim, then there is the multi-track procedure, where claims are generally heard in a senior court like the High Court. So those are three tracks, and normally the court will help you allocate which track to go down when you make your claim. One other option, if you've got a fixed money claim of up to £100,000, is to use something called money claims online, which, as its name suggests, is where the bulk of the claim is dealt with online. So if you've got a fixed price matter that you're pursuing, this person agreed to pay me £10,000, they haven't paid me £10,000, you can use money claims online to expedite the process. So any of the court systems are nonetheless more expensive, more stressful, more time consuming than using something called ADR, which is Alternative Dispute Resolution. So what is ADR? So there are two main kinds. The first is mediation and the other is arbitration. So mediation involves the appointment of a neutral trained mediator to help you try and negotiate a settlement between you. So the mediator doesn't decide it for you, but he or she goes from one party to the other on the day of the mediation, trying to broker and tease out the bones of a settlement that you, the parties, can agree upon. And if that can be arrived at, then the mediator will help you write down a settlement agreement, and then you're done. So mediation is normally a lot cheaper than any of the court procedures, and a lot quicker. It's normally all done and dusted within a day. Any of the court procedures can trundle on for some months or even more than a year. And it's generally less stressful because there's less time involved, and there's a resolution on the day itself. Over 70% of mediations result in a successful outcome on the day of the mediation. So mediation is quite a useful technique, and it's something you can provide for in your contracts. So you can say in your contracts there's a mediation procedure that takes effect automatically if there's a dispute, and the courts have to exhaust that before they go to court. So mediation is one option. The other option for ADR is something called arbitration. So arbitration is a bit different. Arbitration is where you appoint an arbitrator to sort your matter out for you. So the arbitrator is a decision maker, so they're like a judge in that sense. The advantage of arbitration is that you can use a sector expert to help you arbitrate. So there are various bodies that govern arbitrations, like the Central Institute of Arbitration or the London Court of International Arbitration. And these bodies will help you appoint an arbitrator who is an expert on your particular type of business or industry. So what arbitration ensures is that you can get your matter decided by someone who definitely knows about your kind of business, rather than a judge who may be very smart but may have no experience of your line of enterprise. Arbitration can be a little bit quicker because it's not a formal court procedure. The arbitrator with the parties decides on the rules of evidence and disclosure and so on. And it can therefore be a little bit less expensive than court work, although the arbitrator fee itself can be quite high. So mediation and arbitration are alternatives to going down the court system. The best alternative of all, if you're engaged in a dispute, better than any of those or any court procedure really, is to try and negotiate your way to an outcome. That's the cheapest, quickest, less stressful way of sorting yourself out. So the whole idea of LawBite is to provide law that is fast, affordable and easy to use, rather than slow, expensive and complicated, which is what most SMEs are used to. So generally we find that because of the tech, our lawyers are 50% or less of the price of equivalent lawyers, and we'd run all the lawyers through a regulated law firm, our own regulated law firm, which is called Law Briefs, which sits on the platform, and the lawyers are on average 15 years plus qualified, so we don't take any shortcuts in terms of the lawyer experience. We've dealt with over 35,000 SME inquiries to date, and if you want to book a free call with one of our lawyers on any matter, it's really easy to get hold of us through the website or live chat, or just give us a call. So good luck with managing all your disputes, and LawBite is here to help you.